Once you lose it, you can never keep it.
You're from LA. What did you get? So did you want to support her originally and then you came back, or did your feeling change between the her here and came back? Were you able to get into an courtroom at any point? Yeah. Okay. Oh, okay. It got worse. So actually, social media. Yeah. I didn't feel like con máscara, not laughing. Yo esto así de diferente. Ah, sí, sí, sí. ¿Cómo?
Mark, Adrian. We tried. Yeah,
was going to say, people in the corner are going to start screaming when it comes on the corner. So we could be well aware. So I might, you know.
Yeah. Oh, this is so wild.
Are you seeing that on there?
Oh, there we go.
I know. So steady.
I asked you if you can.
I'm not. It's too slow to zoom out for me.
Appointment. They did all the right thing, honestly. At least they still ask. I just
Oh, she's down there now. There we go.
Where's the nice attorney?
Where? I got
Even when you feel low, you can still go. Even when you feel slow, you can still go. Even when there's no hope, you can still go. I never answer to no, man, I still go. Go, 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 yo, go, go, go. Hustle hard, hustle every single day. I'll be making moves till I'm buried in my grave. To the system, I don't wanna be a slave. I've been doing shit my way, or the highway. And in the driveway is a nice range. Cause I grind through the climb, I invite pain.
Anita!
Oh no, I was sitting there. They would have already been. Oh yeah. They're not supposed to. You weren't. How people want to do it, how people do it. Well, I mean, I got the car, but her going in. You got her going in. I mean, I was actually
Well, I'm here for Jenny, and I think we all are here because we think that what happened
Hola, buenos días, ¿cómo están todos? ¿Ya listos? Dice Tommy, Patty para Hollywood. ¿Qué más quisiera yo, no? Que ir a ganar eso que ganan allá. Qué bárbaro lo que hemos estado viendo. Muchísimas gracias a todos los que se conectan esta mañana. Bienvenidos. Yo creo que voy a abrir la ventana porque sí tengo como calorcito. Ahí les voy. Bueno, no hace calor, está fresco, pero digo, aquí con tanto aparato que uno tiene, el calorcito llega. ¿Cómo están todos? Buenos días a todos los que se conectan. Mira, de Puerto Rico, qué lindo país. Bueno, qué linda ciudad en Puerto Rico. Qué lindo. Johnny, dice suerte Johnny. Aquí estoy, aquí estoy. Saludos hasta España también. ¿Ya listos para el merequetengue del día de hoy? Yeah. Miren, muchachos, estoy entre, o muchachas, a todos en el chat, estoy entre que me tomo mi proteína y mi café, porque necesito muchos líquidos, porque hablo y hablo y hablo y hablo. Y no sé ustedes, pero a mí se me seca un poquito la garganta, sí, no te me ando aguantando las 9 horas corridas así sin tantos líquidos y sin tantas cosas energéticas. Oigan, estamos viendo qué impresión la gente que se espera afuera de ahí, ¿no? De la corte, cómo las personas llegan. Salúdame, te veo desde Cerdeña, dice Daniela. Hola, Daniela, ¿cómo están? La gente que se espera desde temprano a ver a Johnny, aunque sea de lejos. Ustedes contéstenme, vamos a hacer una encuesta. No sé si ande por aquí Alex, pero si me puede ayudar Alex a hacer la encuesta. Si ustedes estuvieran en Virginia, ¿ustedes también madrugarían para ir a ver a Johnny, aunque sea de lejos? ¿Y saben qué? Se escuchaba mucha gente latina. También noté eso, que se escuchaba mucha gente latina. También dice que todos irían. Ya llegó nuestra querida y adorada jueza. Ahí está Michelita.
My understanding that defense is resting, is that correct? All right, I'm not going to bring the jury out just to take them back in. So
dice,
after we finish our
dice,
motions,
no voy a traer al jurado de venida y llevarlos para afuera. Ahora está descansando la defensa. Ahora siguen los de Johnny. Dice, tuve manera de descansar. La verdad, me aventé el en vivo de anoche de Patty. Y estuvo buenísimo. Entonces, ahí les encargo que esta vez, si ya llegaron, pongan su like. Espero que los que ya están aquí, por favor, pongan su like. ¿Cuántos likes tenemos? Vamos a tener esto que...
Yes, sir. Good morning, Your Honor. May it please the court, Ben Chu for plaintiff Johnny Depp. Mr. Depp hereby moves to strike defendant Amber Heard's counterclaims.
Están haciendo una que no ha aportado convincentes evidencias y que bueno, pues ahora
Thank you.
Moreover, Your Honor, the court should also strike defendant's claim for immunity and attorney's fees based on Virginia's anti-SLAPP statute, as she is not entitled to immunity under the statute.
Ella no está en un estado de inmunidad y que le está pidiendo el abogado que por favor revise cuidadosamente muchas de las cosas que
I would
están.
mention, however, Your Honor, that because this is not included in our brief,
dice, le voy a pedir su señoría.
Record evidence whatsoever.
A veces me encanta esa palabra, whatsoever.
Even saw any of the 3 statements that Mr. Waldman made prior to being served with the counterclaims in
que
this
necesitan ver los artículos que Waldman ha hecho.
Ms. Heard had signaled for the past week that she was planning to call Mr. Depp in her case in chief.
What?
And it was our anticipation that she would try to fill what we believe is a gaping hole with respect to the elements of her proof. Again, there's no record evidence whatsoever that Mr. Depp ever saw any of the three statements about which Ms. Heard is purportedly
Dice que no hay
suing
ninguna
him for
evidencia de
$100
que
million.
Johnny haya visto esos
As your
tres
honor is aware,
statements
the elements of
que acá
defamation
la
are as
señora
follows.
Amber
One,
ha
publication
publicado.
of two, an actionable statement with three, the requisite intent. See Thorpe versus Sanders, 285 Virginia 476 at 2013. The requisite intent for defamation against a public figure
Dice que
is
están
actual
hablando del
malice.
trailer de
That is,
difamación
the statement must be made with knowledge that it was false
que
or with
se
reckless
hizo con la
disregard of whether
información
it
de
was
que todo
false
lo que
or
se
not.
dice ahí es falso.
See Sanders v. Harris, 213 Virginia 369 at 372, a 1972
Y
case.
bueno,
See also Jackson v. Hartig, 274 Virginia at 2019. Reckless disregard, as your honor is aware, quote, is not measured by whether a reasonably prudent person would have published or would have investigated before publishing, ellipsis.
que no
There
se
must
hizo
be
ningún tipo de
sufficient evidence to
investigación
permit the
antes de que se
conclusion
publicaran estos
that the
artículos,
defendant, in fact, entertained serious doubts as to the truth
pero
of
que
his
se hicieron
publication,
demasiadas,
unquote.
que
Saint Amant
que
versus Thompson, 390
que
US
se
Supreme
fabricaron
Court,
demasiadas dudas
727 at 731.
a partir de eso, o sea, no se
Your Honor, the
publicó
evidence
algo con
shows that
previo
Ms. Heard cannot
conocimiento
prevail
de la
in her
verdad,
claim because she cannot and did not establish that Mr. Waldman made the statements with actual malice.
dice que no se
Mr.
puede,
Waldman testified that
permítame,
he
déjeme.
conducted extensive investigation and reasonably believed that the three statements he made were true. Ms. Heard presented nothing.
que la señora Heard presentó
to
nada,
contradict
nada,
that
nada. Están
undisputed
hablando de
fact.
los tres artículos que se hicieron,
Ms. Heard has no evidence of direct
que la señora
liability,
Heard no
because
tiene
obviously
ninguna
liability is
evidencia.
direct and vicarious liability, but it bears noting that she has no evidence of direct liability and cannot prove
Que no tiene
actual
ningún
malice
tipo
by
de
Mr. Waldman
prueba
when making the three statements
de que
at
por
issue.
los
It
artículos
is
del,
undisputed
como
that
diciendo
Mr.
de que
Depp
también
did
por
not
él,
make
por
any of the
culpa
three
de él,
statements at
ella
issue in
perdió
Ms. Heard's
trabajo,
counterclaim.
o sea, no hay ninguna prueba.
Moreover, in order for Mr. Depp to be liable for the conduct of one of his attorneys, there must be some showing that he directed, participated, or otherwise authorized Mr. Waldman to make the statements at issue. There is no such evidence on the record that Mr. Depp directed or otherwise authorized Mr. Waldman to make the three allegedly defamatory statements at issue in the counterclaims. Indeed, there is no evidence of
No hay
any
evidencia, se está diciendo que
communication or
todo lo que están
coordination between
presentando
Mr. Depp and Mr. Waldman
no son
regarding
suficientes
the
las evidencias
counterclaim
sustentables
statements or anything
para
else.
acusar a
For
Johnny.
this reason as well, Your Honor,
Y estos
Ms. Heard
tres
cannot meet the
artículos
burden of proving that Mr. Waldman was
tampoco
acting within the scope
es-
of his employment as our agency on behalf of Mr. Depp. Again, it bears noting that there's no evidence that Mr. Depp even saw
que no hay ningún
the
tipo de
statements by
evidencia de
Mr.
que el
Waldman
señor Depp
until he was sued,
vio
served with the counterclaims well into this case. It was
que
more
con el tipo
than a year
de
after
cargos que
Mr.
se le
Depp
quieren
filed
hacer en
his
este caso,
complaint. And Ms. Heard lost a series of motions to dismiss that she finally asserted her counterclaims, most of which have already been dismissed by opinion letter of this court.
que esto se ha desestimado,
Whereas here, there is
muchas
no
de las
evidence
pruebas
of
que han
direct
sacado
liability.
aquí en la corte.
Ms. Heard must rely on a theory of vicarious liability to hold Mr. Depp liable for the actions or statements rather of his purported agent, Mr. Waldman. Vicarious liability is by definition, quote, liability for the tort of another person, unquote.
Que,
So to hold Mr. Depp liable for Mr. Waldman's statements, Ms. Heard must establish that Mr. Waldman himself committed all the elements of defamation.
dice que están aquí nada más aclarando que Mr. Walma es el que también tuvo responsabilidad en escribir estos tres artículos,
2018 case.
que
Quote,
fue,
vicarious liability is liability for the tort of another person.
es que no sé cómo explicar liability
It
en
necessarily
español,
follows that a
es
claimant cannot make out a case
cuando
of
te
vicarious
demandan,
liability against an
alguien me puede
employer
decir nada
without
más
first
cómo lo
proving
puedo
that the
traducir en
employee
español,
committed
lo de
a tort
liability,
within the
cómo
scope
lo
of his
puedo
employment.
explicar, pero es,
See also
son como los,
Ralston Pontiac
las
Court
consecuencias
versus Alston,
económicas
236 Virginia, 152 at page 156. which standard Ms. Heard has not met. And Your Honor, we cite a string citation to cases
que han
from
citado aquí muchas
other jurisdictions, which we obviously are not binding on the court, but we believe are influential. We presented those to the court for its review. It is Ms. Heard's burden to prove by clear and convincing evidence, or ultimately,
que la
to
señora
prove
Heard,
actual
les digo lo mismo, no ha
malice by
presentado
Mr.
evidencias
Waldman, not Mr. Depp.
que sean
And
realmente
while it is
factibles, que
well-settled
puedan estar
law in
acusando lo
Virginia,
que
as Your
ella
Honor has pointed
quiere
out
culpar
last
al
week,
señor Depp,
that an agent's knowledge can be imputed to a principal, and this is the Allen Realty Corp versus Holbert case, 227 Virginia 441 at 446. Ms. Heard's counsel cannot cite any case law
que la
stating
señora
that a
Heard no
principal's
ha podido
knowledge is
citar,
imputed to an agent. In other words, Mr. Waldman must have made the statements knowing that they
que
were
el señor
false
que
or
hizo
with
estos
reckless
artículos,
disregard as
el
to
que
whether
escribió
they were
estos
false.
artículos ha
And
de
Mr.
saber
Depp's knowledge cannot be imputed to him.
que en el
There is no
conocimiento
evidence in the
de
record that
Johnny
Mr.
esto no
Waldman
puede ser
knew
como
the
que
counterclaim
no se lo
statements
pueden
were false.
achacar a él.
Indeed, Mr. Waldman did not even know Mr. Depp or
Dice
Ms.
que el que
Heard
escribió
at
los
the
artículos
time
ni
of
siquiera
any of the
conoce
alleged
al
incidents
señor
at
Depp,
issue, and thus had no personal knowledge
no
of
tiene
what
ningún tipo de
transpired.
conocimiento personal,
And this is reflected in
y
the
esto
trial
se
transcript
refleja
that Mr. Waldman
en la
met
corte,
Mr. Depp first in October of 2016, long after the fact.
que apenas se conocieron
Nor is
en la
there any
corte en
evidence
el
in the record
2018
that
cuando
Mr.
lo
Waldman
demandó Johnny,
subjectively entertained any serious doubts about the falsity of the counterclaim statements. Quite the opposite. The evidence shows, and it's
dice las
unrebutted, that
evidencias
Mr. Waldman had very reasonable
qué guapo se ve
grounds
Johnny
to
hoy,
believe, and he did believe, and will to his dying day, that Ms. Heard's claim of abuse were patently false.
que todas las
Mr. Waldman
acusaciones de la
testified at
señora
length
Amber
about 29
repetidamente de
witnesses he
abuso son
believed
falsas,
disproved Ms. Heard's false claims of abuse.
y que pues
See the transcript at page
y que vea por favor el
6008 through
transcript,
6012, and I won't run through all of that. But his testimony that two trained police officers,
y que también los testimonios de los
were called to the
oficiales,
penthouse on
de acuerdo
May
al
21,
penthouse, ¿se acuerdan los que
2016,
entrevistaron los que
and saw
fueron?
no signs of injury
No vieron
on
ningún
Ms.
tipo de
Heard's face,
señal de
as
daño
well as
en
quote
ella,
Ms. Heard's own witnesses who have testified in various forms at various times that there were no injuries to her face
no tenía
whatsoever
ningún tipo de
between May
daño
21st
cuando la
and
fueron
May
a ver a su
27th,
departamento, al penthouse,
2016,
en
when she
2016,
walked in
cuando
to
hablaron,
court with her publicist, her lawyer,
y que
her former
su
best
su
friend who no longer
publicista, su
speaks with her,
abogado,
for a no-notice ex parte TRO. Some of the witnesses who
algunos de los
Mr. Waldman
testigos,
has cited, they include Laura Devenier, Melanie Iglesias, who, as Your Honor recalls, was Ms. Heard's makeup artist, who decided to end any professional or personal association with Ms. Heard.
que también su agente, que también terminó
Samantha
cualquier tipo
McMillan,
de, no su
Hilda
agente, su
Vargas,
representante,
Isaac Baruch,
que terminaron
Trinity
con ella
Esparza,
sus
Cornelius Harrell,
labores,
Alejandro Romero,
Alejandro
and
Romero,
Brandon Patterson, just to name a few.
que también algunos de los
No
testigos que
reasonable
estaban en el
jury
edificio, pues que no le
could
vieron ningún
find that
rasguño a la
Mr.
señora,
Waldman acted with actual malice
que
in
ella
making
actuó
the
con
allegedly
malicia, con
defamatory statements. He was
malicia.
not present for the alleged incidents. He has no personal knowledge of any of the alleged incidents. What
Que él
Mr.
no
Waldman
tiene ningún
knows
tipo
is
de
the product of the
conocimiento,
legal work he did, the sleuthing he did on behalf of Mr. Depp. Ms. Heard cannot possibly show that Mr. Waldman acted with actual malice and her defamation claim
que la
must
señora
fail.
Heard no ha podido probar
Two,
que el que escribió los
Mr.
artículos
Waldman
actuó
is
sin
an
malicia.
independent contractor, not an employee. It is axiomatic, Your Honor, that a person who hires an independent contractor
Que la persona
is
que
not
contrata
liable for
una
the
persona
independent contractor's
individual, un
actions. See
así,
Sanchez versus Medicorp Health System, 270 Virginia, 299 at 344. An independent contractor is a person who is engaged to produce a specific result, but who is not subject to the control of the employer principal.
está dando una definición de qué significa cuando te contratan.
Versus Sachno, 261 Virginia, 378 at 284. That's a 2001 case.
que una persona
An
que
outside lawyer retained by a client in connection with litigation is an independent contractor.
es
See
una persona
King versus Dalton, 895 F sub 831, Eastern District of Virginia, 1995, where Judge Ellis, a legendary jurist known by all Virginia practitioners, held that, quote, a law firm attorney
Una
working with a client
firma de
is
abogados
nonetheless an independent contractor
son
and is not an employee of the client corporation. In that case, the employer was a corporation, but the same logic applies when it's an individual like Mr. Depp.
cuando es está hablando de los contratadores, de contratos y cosas así que
Indeed, clients hire lawyers to
los
obtain
clientes
specific results,
contratan
to obtain
abogados
specific results, but they do
para
not
tener
control the
específicos
means by
resultados.
which the results are accomplished. Lawyers, as Your Honor has reminded us, are subject
Los
to
abogados
professional obligations
tienen
to
la,
exercise independent
tienen la
professional
obligación
judgment.
de
We
independiente,
are not at the whim of our clients as much as we want to serve
que
them.
no podemos tener
See
como que el
Virginia
control de que nuestro
State
cliente
Bar
gane
Professional
aún
Guidelines,
cuando
Rule
nosotros queramos.
1:2 and 2.1. And just to quote 2.1, in representing a client,
Representar un cliente, el abogado debe de hacer su trabajo 100% profesional.
Mr. Waldman is,
El
as a matter
señor
of
Waldman
law, an independent contractor,
es un-
and
es
Mr.
un-
Depp cannot be held responsible for any alleged
Es
tort
independiente y total que él no puede ser
his attorney,
responsable
particularly
de,
for
de
statements
estos,
about
de
which
estos
he
artículos.
was unaware until he was sued for them.
Y dice que su abogado,
Mr.
él se
Waldman
hizo enterado
testified
hasta
in
que
his
lo
unrebutted
demandaron, ¿no?
That he
Okay.
has his own law firm. He's
Que él
not an
tiene su
employee
propia
of
firma
Mr.
de
Depp,
abogados, que él no es
Mr. Depp
empleado,
or none of his loan out companies have issued him a W-2. And Mr. Waldman provides legal services to clients other than and in addition to Mr. Depp. And that's found at the transcript, page 6020 through 21. All of that is unrebutted by Ms. Hurd. Mr. Waldman's statements, the third reason for which we respectfully submit
el artículo de este
counterclaim should be
señor
stricken
Waldman
is that Mr. Waldman's statements were protected opinion. And I won't go through all
era
of that,
su
but
opinión.
very briefly, taken in their proper context, the counterclaim statements are non-actionable expressions of opinion.
Que no
entitled
son,
to
los
protection
artículos
under
no
the
son
First
una
Amendment.
opinión
See
personal,
versus
que
Robert
tienen,
Welch,
está tratando,
418 US
está dando como
323
definiciones de cosas
339. That's a
como muy
1974
técnicas de abogados.
case from the United States Supreme Court. See also Shacker v. Bufault, a Virginia Supreme Court case found at 290 Virginia 83.
La Corte de Virginia encontró
A 2015 case noting that
en
where,
el
quote,
caso
all sides of the issue
que
as
todas
well
las
as the
partes del
rationale for
problema,
the speaker's view were exposed, the assertion of deceit reasonably could be understood only as the speaker's personal conclusion, unquote, and finding an accusation of deceit to be
encontrar una
opinion.
acusación en
In context, Your Honor, any
contexto,
reporter
su
or
señoría,
any reasonable reader would
los
understand and
lectores,
expect a lawyer associated with Mr. Depp as Mr.
cualquier
Waldman was to
acusación,
challenge
cualquier
Ms. Heard's
acusación va
version
a estar
of the
hecha
inherently
para el señor
controversial
Depp.
events of the parties'
Cualquier
marriage.
persona que lo
Just as
lea,
Ms. Heard's
dice las
lawyers
chances,
were quoted challenging Mr. Depp, and Your Honor
las
will
chances
remember
de que la señora
the
Amber
context
estaba
of these
como
quotes that
retando,
were in
provocando a
British tabloid,
Johnny,
where Mr. Waldman's statements were buried well into article in which
en
both
este artículo que el
points of
señor
view,
Waldman escribió,
were clearly expressed.
estaba
And
realmente
Mr. Waldman
claramente
was clearly
expresando,
identified not as an
identificando.
independent expert on the U.S. Constitution,
Dice, no
but
tienes que
as
ser un
one of
experto en la
Mr.
Constitución de
Depp's
Estados Unidos.
attorneys.
Um,
C. Chavez, 230 Virginia 112 at page 119, quote, the
Quota.
most unsophisticated recipient of such a claim, i.e. any reader of the British tabloid, made by a competitor against another could only regard it as a relative statement of opinion grounded upon the speaker's obvious bias, unquote. Mr. Waldman has never did anything to hide his support and belief in Mr. Depp. Finally, Your Honor, and for the rest,
Dice, finalmente,
ultimately,
Su
Mr.
Señoría,
Waldman's statements reflect the existence of two competing narratives and are merely his subjective view about events that he never claims to have witnessed, and there was no doubt about that. Turning to the second part of the argument, which will be more abridged, Ms. Heard is not entitled to anti-SLAPP immunity.
Que la señora Heard no tiene, en pocas, les estoy haciendo tratando de darles una conclusión, la señora Heard no tiene inmunidad en esto, que ella tuvo participación malosa en todo esto, que estaba haciendo, pues, participando en estos artículos.
The immunity provided by this section shall not apply to any statements made with actual or constructive knowledge that they are false or with reckless disregard for whether they are false. Here,
Dice
in
aquí,
addition to Mr. Depp's
en
testimony,
adición con el
several
señor,
witnesses have
diferentes
testified
testigos han
that, A, they
testificado
never witnessed Mr. Depp abuse Ms. Heard,
que
and B,
han
that they
dicho
observed
que la
Ms.
señora
Heard
Heard
without
abusaba
any
de
injuries,
Depp,
marks, bruising, swelling, etc.
que
during
le vieron
periods when Ms.
moretes,
Heard claimed to
hinchones
have
y
injuries,
etcétera,
marks, bruises, etc.
etcétera.
Such witnesses include,
Muchos,
but are not
muchos
limited to, Isaac
testigos
Baruch,
incluyen
Kate James, Dr. David Kipper,
los doctores,
Nurse
está
Debbie Lloyd,
mencionando a los que vinieron a
Officer
ser
Science and
los
Haddon, Officer
oficiales
William Gatlin, and former U.S. Marine Starling Jenkins.
y
Ms.
una
Heard's request for anti-SLAPP immunity should be stricken, and even if there were disputed facts as to that, the anti-SLAPP immunity does not apply because the defamatory implication of Ms. Heard's statements are
la
not
difamación que la
solely
señora
relating
Amber
to
está
a
haciendo
matter
en su
of public
artículo,
concern, as is required under the statute. As has become quite clear, Your Honor,
que está
Mr.
demasiado
Depp
claro, señora,
is not suing about any of the public policy commentary
dice que
made
está
by the ACLU
testificando
when it
o
drafted
que
the op-ed,
Johnny no ha
and Ms.
demandado
Heard put her name to it.
por nada de lo,
What he is suing about
por lo que él está
here are the
demandando
three
aquí y
statements
por sus,
that were directed at him.
porque
He has
esos,
no
esos
issue with women's
artículos
rights.
eran
He supports
directamente
women's
para él.
rights. In fact, he was the one, Your Honor, as Your Honor knows,
Dice
who
eso,
made that first $100,000 contribution to
dice
the
usted sabe, su
ACLU,
señoría,
and he
quién
made
fue el
it
que dio los
also
$100,000 primero
to the CHLO.
Your Honor, at this point, I'm
como
gonna
de,
object.
como de
Mr.
caridad,
Chiu's
ya saben,
largely
a
just
la
read his brief
asociación.
and confined his arguments to those directed in the motion, but like we saw with the last motion to strike, he's now directing his arguments to something other than what's at issue here, and I would object because I think making an argument not to you, but to the cameras, it threatens.
Dice que él está haciendo este argumento no para la jueza, sino para las cámaras. Él está diciendo, está haciéndose todo este choro porque quiere victimizarse en las cámaras.
Thank you, Your Honor.
Y la señora le dice,
As I was
continúe,
trying to
continúe.
say, what Mr.
Como le
Depp
estaba
is suing
diciendo,
about
el
are the
señor
three
Depp está
statements,
aquí demandando,
and it's very clear,
porque es muy
despite
claro
the pious opening statement,
que estos artículos que fueron
about the First
abiertos,
Amendment,
tan descarados,
that with the testimony
que fueron
of Terrence Doherty and the emails that were admitted as exhibits,
como
that
los
the
emails que se
ACLU
exhibieron,
and Ms. Heard were
que la
conspiring
señora
to
Amber conspiró,
make it very clear
que fueron
that
muy
those three
claros,
statements
esos
were
dos,
related to Mr. Depp.
esos artículos
Because
fueron
otherwise,
conspirados
nobody
en
had
contra
any
de
interest
Depp.
in the article. It's crystal clear
Y
from
está
that.
sumamente
They wanted
es tan
to time this thing
cristalino
with the
como el agua
release
de
of
Canadá,
Aquaman, which was her first
de
film
de los
of any
glaciales.
significance in
Es
terms of,
significadamente
popularity. And
claro,
to
o
do
sea,
that,
sin duda.
that's very clear.
Y eso es demasiado
the
claro.
charade that this had something to do with public policy
Esto
is
tiene que
risible,
ver
and
con
that
las
is
con las
not
cuestiones
why the
públicas.
anti-SLAPP protections were enacted. They were enacted to
Y ellos
protect
estaban
the rest
actuando,
of the article,
protegiéndola,
not what Mr. Depp was suing about.
pero que eso no es lo que él
As
está aquí
generally analyzed
demandando
by the
ahora.
courts, a matter of public concern is one which relates to, quote, a matter of political, social, or other concern to the community, unquote, as opposed to a matter of only, quote, personal interest, unquote.
Esto es por
That's
intereses
versus Myers,
personales.
461 US 138 at page 146. Instead,
En todo,
the defamatory implication at issue in each of the
aquí la
three
cuestión difamatoria
statements at bar relate to the personal grievances between Mr. Depp and Ms. Heard, which does not rise to the level of a matter of public concern with broader implications for society beyond the two litigants in this action any more than Mr. Waldman's statements. I mean, adding the gloss of public policy might immunize the statements that relate to public policy, but those are not at issue here. Mr. Depp agrees with those statements. We're talking about the three statements that they very intentionally and very cleverly put in to make it clear the implication that it was about Mr. Depp.
Que las implicaciones fueron
working around the clock with Eric George,
que trabajando con el a contrarreloj con George.
And Your Honor remembers the testimony of Mr. Doherty about the consternation at the ACLU when they realized that USA Today and everybody else who read the article knew darn well.
Cualquier persona que leyó